Then call case 104068 and 104432, State versus Tabatha Adams.
Christina Curls of the Appellate Defender Office for Ms. Tabatha Adams. I would request 3 minutes for rebuttal.
3 minutes of rebuttal is granted. Thank you.
I'd like to focus my argument on the second and third issues of the brief, arguing them together, and submit the first on the brief. Unless there are specific questions, I will be talking about some of the arguments as they relate to the second and third, but unless there are specific questions relating to the first, I'll just submit that on the brief. Both the second and third issues relate to an ineffective assistance of counsel claim. The second issue relates to a 1507, and the third is a motion to withdraw a plea. The law relating to both of them is the same, except for the added component of manifest injustice for the motion to withdraw a plea. So for the most part, I'm just going to argue them both the same. In this case, Ms. Adams' counsel for her plea, her representation fell below an objective standard, and but for that deficient representation, there's a reasonable probability that Ms. Adams wouldn't have pled. And there are numerous different reasons why we asserted that Ms. Eckelman's representation fell below an objective standard of reasonableness. And the first is that she failed to ensure that Ms. Adams actually understood the consequences of her plea. According to Ms. Adams, throughout the course of the representation, Ms. Eckelman explained at least four different potential sentences for the charges, for the aggravated indecent liberties. In their first meeting, while she did tell Ms. Adams that the sentence was 25 to life, she also told her that there's no way as a first offender that she would actually get a life sentence. The second time, she told her that she would have to do some prison time. The third time she said, well, yeah, it's 25 to life, but with prison overcrowding and good time, there's no way you're going to serve that. And finally, the day of the plea is when she actually told her what the actual sentence was. But because of all of these other misrepresentations, Ms. Adams was still unclear as to exactly what the consequences, what her sentence for that plea would be, which is clearly evidenced by a letter that she sent her attorney just 4 days after the plea hearing, in which she expressed confusion that everybody was talking about 25 to life when it was her understanding that her sentence would just be 25 years in prison. So that's the first area of deficient performance, is that Ms. Eckelman did not ensure that her client actually understood the consequences of the plea, and she didn't clear that up once Ms. Adams brought that confusion to her attention. In fact, it was exacerbated when Ms. Eckelman asked Ms. Adams whether or not she was going to have people come and testify at sentencing for her, when she didn't explain to Ms. Adams that regardless of whether or not you bring teachers to testify, regardless of whether or not your father or your stepfather testifies, regardless who comes to testify at sentencing on your behalf, it's not going to change the fact that you will be sentenced to life in prison with no possibility of parole for 25 years.
What about the fact that the judge informed her? He said, you need to be informed if you're convicted of these charges as an off-grid felon. That would be a life sentence, okay? ? And it would be a mandatory 25 years in prison before you could apply for parole. There's no good time credit given on this case. And he continues on. If she didn't understand that it was 25 years to life, which I think is what you're saying, she at least was, explained to her by the judge.
What was explained to her?
25 to life.
Now, I would agree that the judge did, in fact, say that.
He said it will be a life sentence, and it'll be a mandatory 25 before you can apply for parole. And he asked if she understood.
And that is what the district court said, and that's actually what her attorney told her that morning of the plea. Right. But it doesn't change the fact that she clearly didn't understand that that's what it was, based upon the different misrepresentations her attorney had made before. Because from the very first meeting, her attorney had told her it's 25 to life, but you never get life for a first offense. And then it changed in subsequent meetings. So even though that's what the district court told her, it's clear that she didn't actually understand that.
So she's saying she not only was told by the district court very specifically, she was also told by her attorney that day it would be 25 to life, but that she didn't understand those very specific statements because she'd been told otherwise.
She had been told previously that it was 25 to life,
Right.
but that it was unlikely that she would actually receive that sentence. So the fact that the district court said it's 25 to life doesn't change the fact that prior to that, Ms. Eckelman had said that, yeah, that's your sentence, but it's unlikely that that's what you're going to get. And Ms. Eckelman didn't clear that up afterwards and made the issue worse by not explaining to her that regardless of how many witnesses you present in mitigation, your sentence is still going to be life in prison with no possibility of parole for 25 years.
Wasn't Ms. Adams informed that one of the plea conditions was no departure motion?
That, once again, and this is also an issue that or something that I explained in there, while it was stated that there were no motions for departure, there's no evidence in the record that Ms. Eckelman actually explained to her what exactly that meant. This isn't a defendant with numerous experiences with the law, that she's been in front of a sentencing court, and she understands what all of these terms mean. This is her first offense, her first conviction, and there's no indication that anybody actually explained to her what no departure motions mean. And the fact that she didn't understand that is clear in not only her letter to Ms. Eckelman after the plea hearing, in which she asked, is there any way that he would give me 25 years or less, but also at the sentencing hearing itself, when she did have all of these people testify in mitigation, and when she submitted, or the defense submitted all of these letters in mitigation, and when she herself asked for less than 25 years. Even though, the words were said, no departure motions, there's no indication that she actually understood what that meant. And I know one of the issues that the state raised in their brief is that she has a college education, but simply because someone has a college education doesn't mean that they're going to understand the legal terms and what the legal procedures in a case like this means unless they're actually explained to her.
Since she's having trouble understanding everything, has anyone explained to her that if she withdraws her pleas and is convicted and they reinstate the charges that were dismissed, and she's convicted of both aggravated indecent liberties and aggravated criminal sodomy, that they can be run consecutively and she could be serving 150 years?
That was explained to her prior to the plea as well, except for, according to Ms. Adams, what was told to her is if she went to trial, it would be 50 years. Not that it was a possibility that they would be run consecutive, but that she would be facing 50 years in prison and that she would die in prison. That's what her attorney, and that goes to the coercion part that I talk about in issue 1 and a little bit in issues 2 and 3. But
if it's likely, if can't an attorney tell his or her client the most likely sentence, and given the facts of this case, I probably would make that guess that they would be run consecutive, given that there were more than 50 photos depicting acts with this 8-year-old. It was very likely that it would have been a hard 50.
there is a difference between telling your client it is likely that this is what will happen, and you need to decide whether or not you want to take that risk, and telling them this is what will happen. It should be her decision with all of the information to make that decision for herself, not her attorney giving her misinformation which clouds her decision.
There was an evidentiary hearing on this case, is that right, before
Yes.
Judge Hampton?
There was.
And I'm confused because you seem to be suggesting that the court found your client credible when she said she didn't know it was 25 to life, or she didn't understand that she couldn't file a departure motion, and yet Ms. Eckelman testified that she did inform her and that she did understand that she wouldn't file a departure motion. The problem we have is the judge didn't make any findings about either way, who he believed, and he seemed to be going straight to the prejudice prong, although that's not even very clear. What do you recommend we do about that? Do we need to remand, or do we And can we go straight to prejudice, or do we need to know who the judge believed in terms of whether, we meet the first prong here of the Strickland test?
Well, I would say that is a little bit, because the district court didn't make specific factual findings. I mean, obviously, advocating for the defendant, I'm going to be advocating her side of it.
But we can't make that finding.
You can't.
So what should we assume about the first prong without credibility findings?
I would say that if based upon the record and the lack of findings, you can't make that determination, I would say that the appropriate remedy would be to remand for the district court to make those actual factual findings, and then we just likely end up back here making the same arguments.
Why didn't your client have the obligation to get the adequate findings? Like we said in the Seward case about the challenges to disproportionate on Jessica's law, we've said that the defense counsel has the obligation to make certain that the court complies with the provision that says findings of fact.
I would say that given the, and I understand that argument, I would say that given the actual decision that was made, that the district court did make a finding that Ms. Eckelman's representation did not fall below the standard of reasonableness, even though it didn't explain the basis of that finding. It did make that finding.
And that kicks us into the other presumption where we presume that district courts have made all the factual findings necessary to support their ruling. And if he found that didn't pass muster on the first Strickland prong, then we're assuming that he must have found the attorney more credible.
But then you look, I mean, if we're just talking about the sentencing issue, I mean, that's not, I don't believe that that's the strongest issue, because then there were also other issues with her representation, including the failure to investigate the defenses. And I understand she stated that she did investigate compulsion, and she investigated battered woman syndrome. But there was also another pretty clear defense, and that's that in order to be convicted of aggravated indecent liberties or the sexual exploitation of a child, the actions have to be done with the intent to arouse or satisfy the sexual desires of either the offender, the child, or in the case of sexual exploitation of a child, another. And if, as Ms. Adams stated, and as she told her attorney it was true, that her actions were taken out of fear that her ex-boyfriend would beat her or kill her daughter, then that doesn't satisfy the intent element of either aggravated indecent liberties with a child or sexual exploitation of a child. There's not the same specific intent requirement in aggravated criminal sodomy, but it doesn't change the fact that her failure to investigate Ms. Adams's claims of the abuse, her failure to order any sort of psychological evaluation, to do anything to substantiate Ms. Adams's claims of the abuse, was a failure to investigate possible defenses, because in addition to our assertion that it was a failure to investigate compulsion and how battered woman's syndrome would apply to that, it was also a failure to investigate whether or not there was a defense based upon the strict elements of the crime. I see my time is out for rebuttal, so I'm a little confused by your statement that you think that the judge did find Ms. Eckelman was effective. What? Can you point me to that?
It was not, I thought you said.
I'm going to have to do that.
I misunderstood maybe. I understand. I mean, we agree he didn't make any credibility findings, no fact findings. Do you think he made any finding regarding the first prong?
I believe, and I will look at this and let you know if I'm wrong on rebuttal, but I believe there was a finding that her representation did not fall below the standard of reasonable.
I'd like to know about that, because if that's the case, and we assume that he found her attorney credible then, or his attorney credible, then we wouldn't need to even go on to the second prong if we agree with that first.
I mean, yeah, if
See
you
what I'm
agree
saying?
with the first finding,
Right,
then
right.
the second, you wouldn't need to go to the prejudice prong. And
Right.
I'll submit the prejudice prong on the brief as I'm out of time. Our argument is that the finding on the first prong was erroneous based upon the facts and the level of representation that Ms. Eckelman did provide,
All right.
or didn't provide.
Thank you.
Thank you.
May it please the court. My name is Kevin Salzman, Assistant Ford County Attorney for the appellee, the state of Kansas. The appellee respectfully requests that this court affirm the district court's denial of Ms. Adams' motions in this case and deny her appeal in this case. The essential issue before the court is this ineffective assistance of counsel claim. And in her brief, Ms. Adams, in her brief and at her motions hearing, Ms. Adams alleges certain behaviors, certain inactions, certain statements made by her trial counsel that coerced her, that pressured her, that shamed her into accepting this guilty plea. And she claims once at her motions hearing that were it not for that behavior, she would not have pled guilty. Unfortunately, for the defendant's argument, those statements, those actions, those behaviors are either contested by the record or outright refuted by the record.
But we don't have any findings, factual findings by the trial judge.
We do not have any factual findings as to the ineffective assistance of counsel. I wrote some notes as to what the trial counsel found at the motions hearing, and
As to what the judge found, you mean, or?
Yes, I made some notes as far as what the judge's
Okay.
holding was at the end of the motions
And
hearing.
how do you read that? It looked to me like he went straight to prejudice, although he didn't say he was going straight to prejudice, but it kind of looked to me like he didn't make any findings on the first prong.
As far as specific findings, no, I did not find any. The findings that I found that the trial court made, number one, that Ms. Adams did not claim actual innocence at the motion hearing. The statements that she had made would have, quote, certainly resulted in conviction if they were presented to the court.
We don't know whether he believed Ms. Eklund or whether he believed the defendant.
No, Your Honor. There's nothing in the record of the motions hearing that I can point to and say, here the trial judge stated or found Ms. Eklund to be credible as opposed to Ms. Adams.
But nevertheless, you're now asking us to basically make that finding that Ms. Eklund didn't misadvise her client, or that if she did, it didn't rise to the level of ineffective representation. And how can we do that without those findings?
Well, Your Honor, I would simply suggest, even if we take the defendant's assertions as true, and even if we assume that Ms. Eckelman's representation fell below an objective standard of reasonableness, Ms. Adams still hasn't satisfied the second prong, and that's prejudice. The record is replete with examples over and over and over again where Ms. Adams has indicated to her attorney, to the court, various judges, that she wishes to enter into a plea agreement in order to keep her daughter from having to testify. This was expressed in a letter March 1st, 2008, where Ms. Adams mentions wanting to enter into a plea agreement in order to save her daughter from having to testify.
Where is it in the record that she, and I understand that she clearly wanted to enter into a plea agreement, but what we're talking about here is whether she understood the terms of the plea agreement. And I specifically would like you to direct me to what testimony was in the record about whether she understood that she would not be allowed to file a departure motion, other than the statement by the trial court referring to the departure motion.
Certainly. At the motions hearing, with Ms. Eckelman's testimony, Ms. Eckelman was asked about departure motions, and if she explained if she explained departure motions to the defendant, which she testified she did.
But we don't know whether the trial judge believed that because the defendant said she didn't.
Certainly, it became a contest between who to believe.
Right. So let's assume that we don't have that finding, so we have to assume that she didn't advise.
Mm-hmm.
I would like for you to address why that didn't prejudice her, that she didn't know that she could file a departure motion. That the terms of her sentence were going to be 25 years to life. There was no discretion whatsoever.
Certainly, Your Honor. I would direct the court's attention to Ms. Adams' own testimony at the motions hearing, specifically on cross-examination. If I may read verbatim from the brief, the court, Mr. Belling, on cross-examination, asked the defendant, did the judge explain to you there would be a life sentence with a minimum of 25 years and there would be no good time credit? Defendant's answer, yes, he did. Okay, so you understood that. Right, yes. Later on, you understood the only thing you could get was a life sentence and had to do 25 years before you could apply for parole. She replies, yes, I understood that was what the plea agreement was. And the judge asked you if you had understood the terms of the plea bargain. You told him yes. Yes. Do you remember being asked right after that if you understood the plea bargain after she had entered her plea? Right before she entered her plea, do you remember being asked if you understood the plea bargain and if you had any questions about it? Yes.
But all of that goes to the 25 years to life, and none of that addresses whether she understood what she was giving up by giving up a departure motion. Those are two different allegations that she's making.
I understand they're two different allegations, but they go back to the same thing, as whether she could get anything different than a life sentence with a minimum of 25 years before parole eligibility. Departure motion would obviously reduce that. And she said, yes, I understood that at the plea agreement, that's what it was. It was a life sentence with 25 years. Now, at the motions hearing, interestingly enough, the defendant, I believe, touches on a little bit of why she brought witnesses or had letters filed on her behalf at the sentencing hearing. She testified that that was based on her viewing of courtroom dramas. She believed that despite the clear nature of the plea bargain that was made explicitly clear to her twice before she entered her plea, she believed, based on viewing these courtroom dramas, that the judge would still have authority to deviate from that at the sentencing hearing.
Perhaps depart.
Or perhaps depart, yes. But the case law on these subjective impressions, which incidentally Ms. Adams never informed her counsel that this is what her thought was. She never testified. She informed her counsel that's what my thinking was. The case law on that is subjective impressions are not grounds for relief, especially where there's no reasonable basis to support them.
Well, doesn't that sort of go right along with her claim that she didn't understand? She might have been told you can't file a departure motion, but she didn't understand what it was because she still believed right up until that point and afterwards that she could present some evidence and there might be a chance the judge could do something. Doesn't that actually support rather than detract from her argument?
It's interesting, Your Honor, because as the appellant's counsel pointed out, we're dealing with a college-educated woman, an educator herself. She's not a juvenile. She's not an imbecile. She's not mentally deficient in any way. Again, this subjective impression that was never made known all the way up until the motions hearing. It was very unreasonable based on what had been told to her. Ms. Eckelman testified, yes, I spent about 40 minutes with her at the plea hearing explaining it, but I also conferred with her on the 18th, 2 days before the plea hearing, and was certain she understood it. The magistrate judge that took her plea explained the plea agreement twice, and she said, yes, I understood it. And she admitted at their motions hearing, yes, I understood what the sentence was. I understood that's what I was going to get, and I understood that I had the chance to ask any questions, and I didn't. It's curious if that was Miss Adams' impression, all along, why that wasn't made known. She's very obviously articulate enough to write letters to her counsel expressing her thoughts and beliefs on certain issues. They never surface in those letters. Even at her attorney status hearing, after she files a motion or a request to have Miss Eckelman excused as her counsel, she doesn't bring it up then. Again, it's not even in her direct testimony at her motions hearing that she talks about these courtroom dramas. And again, the case law states that mistaken subjective impression, when it's especially when there's no reasonable basis to support it, no objective reasonable basis, is not enough to grant relief. I mean, this is a subjective impression not only that was never expressed to anyone up until the motions hearing, but this was a subjective impression that was extremely unreasonable given the plea that was explained to her, the consequences.
I'm sorry, I apologize. I was going to say, wouldn't it be easier for us to make that finding you're asking us to, that it's just simply her mistaken subjective impression, if we knew whether the trial court believed Ms. Eckelman when she said, I advised her that she couldn't file a motion for departure? Wouldn't it be easier for us, and don't we really need that to assume it was only her subjective impression as opposed to what actually happened, that nobody clarified that for her?
I'm stating, Your Honor, that even assuming that Ms. Eckelman wasn't believed, and that we're believing what the defendant said completely, and even taking into account that this subjective impression that was floating in the back of her head was what caused her to enter the plea, it doesn't matter because the prejudice prong still isn't satisfied. She hasn't demonstrated that she would have gone to trial. It appears, I believe the defendant's opinion about how this case would have been resolved or how this case should have been resolved in her mind is best summarized by the defendant's own words at the end of the motions hearing, where she says, and I'm going to loosely paraphrase, but she says essentially, I'm not saying I'm not, I'm guilty. I'm guilty. I just think what I got is excessive given the events and the circumstances that led me here. This wasn't an individual who wanted to proceed to trial as opposed to take a plea. This is a person who was dissatisfied with the mandatory nature of the Jessica's Law and the provisions under which she was sentenced. So again, even taking everything that Ms. Adams said is true, even finding that Ms. Eckelman's representation fell below an objective standard of reasonableness, which I would submit is not proper given the standard of review and the burden the appellant carries. But even if we jump that and go to the prejudice prong, the defendant still hasn't satisfied that, given all her testimony, all her chances to explain, and whatnot. Going back to the ineffective assistance, if I may, the state essentially contests that Ms. Eckelman engaged in any kind of inappropriate behavior or ineffective assistance of counsel. As this court stated in Chamberlain, it's the defendant's responsibility in this type of scenario to overcome the presumption that trial counsel's assistance is reasonable, and that this court is going to take a deferential view, a highly deferential view, towards trial counsel's actions. Regarding the contention that Ms. Eckelman did not advise her client of the plea, I believe that's already been hashed out fairly well in our discussion thus far. The defenses, Ms. Adams indicates that her client or her counsel didn't investigate possible defenses to the charges, including battered woman syndrome, compulsion, and this jurisdictional defect. Ms. Eckelman refuted that testimony and stated that I did. And even again, I would like to point out that in the officer's affidavit, the arrest affidavit that was filed in this case, Ms. Adams admits to these events occurring in Ford County, Kansas, specifically the allegation that she licked and kissed the victim's breasts and vagina. She specifically stated, according to the officer's affidavit, that occurred in Ford County, Kansas. So there really isn't any jurisdictional defect to investigate. The defendant's own admission proved that there was acts that occurred, aggravated indecent liberties that occurred within Ford County, Kansas. And likewise, the compulsion defense, Ms. Adams testified that these events occurred in Ford County while the co-defendant, the other involved party was living in Nebraska, 6 hours away at least. Compulsion requires a threat of imminent harm, imminent physical harm. 6 hours away is not imminent. There's no testimony or no evidence anywhere in the record that says that somebody was holding a gun to Ms. Adams' head while these events were occurring in Ford County, that the co-defendant had an accomplice there with her, forcing her to engage in this. So based on the defendant's own admissions to the police in this case, a compulsion defense, as the trial judge said at the motions hearing, would have been questionable at best and may not have even been admissible at trial. I see I'm out of time. May I just briefly conclude?
Yes.
Thank you, Your Honor. The state would just again respectfully request that this court affirm the district court's denial of the defendant's 60-1507 motion, the denial of her motion to withdraw a guilty plea, and deny the defendant's appeal in this case. Thank you very much.
Thank you, counsel. Ms. Curls.
First of all, to address Justice Moritz's question about exactly what the court found. In regards to the motion to withdraw plea, the court found that Ms. Adams failed to show manifest injustice. And it looks like in a reference to the 1507, all the court specifically said was has failed to sustain her burden of proof as to ineffective assistance of trial counsel. And then it goes on to state that the allegations of the petitioner, and it lists them, were overcome by the petitioner's realization of the certainty of conviction, the severe weight of the evidence, and not including the evidence reviewed by counsel, and the petitioner's concerns about her future injury to her daughter. So reading that again, it does appear as though the judge did skip directly to the prejudice prong. And as to the prejudice prong, we would argue that there was evidence, and there was evidence to support a reasonable probability that but for Ms. Eckelman's deficient representation, she would not have pled guilty.
But if, as you said, the judge made the opposite finding, are we bound by that? Was that a finding of fact that the judge made, and there's substantial competent evidence to support it, so is that the end of our inquiry?
I don't believe so. I mean, we still look at what the evidence was, and what this court was weighing is, yes, there was evidence to support her guilt. If there wasn't evidence to support her guilt, then charges wouldn't have been filed. But the question is whether or not she would have pled guilty, whether or not she would have taken that risk if she had had all of the information, if she had known that if her attorney had investigated her defenses, if her attorney had informed her unequivocally from the very beginning that it was 25 to life, if her attorney, when she had told her attorney that she had these witnesses to testify, or even when 4 days after the plea hearing she had told her attorney, why is everybody talking about life? I thought it was just 25 years. The question is whether or not she would have still pled. And she testified, Ms. Adams testified at the motion hearing, that while she did want to save her daughter the trauma of testifying, she wanted to go to trial and she was willing to take that risk. And the issue is whether, if Ms. Adams had had all of the information, if she had known that she had had defenses available to her, and the attorney could have just explained to her, well, I don't believe that this defense is going to work. I'm not sure about the reliability of this defense. If she had had that information, would she have still pled? And based upon her testimony was she believed that she had defenses. She believed she had defenses based upon the fact that her boyfriend had threatened to beat her, threatened to kill her, threatened to kill her daughter, and she wanted to go to trial and take that risk. So we would argue that the prejudice prong has been met, that there is a reasonable probability that had she had all of the information in this case, she would have insisted on going to trial. And would we ask the court to reverse the decision of the district court?
Any questions of counsel? Thank you to both counsel. We'll take this matter under advisement.